Good afternoon, Ms. Rivers. Can you hear us?
Good afternoon. Yes, I can.
Great. Let's go on the record, please. In 21 SC 178773, it's State of Georgia versus LeAndre Pittman and Antonio Sanders. Mr. Pittman is here in court with his lawyer, Mr. Brown. Mr. Sanders is here in court with his lawyer, Mr. Hoover. Mr. Hiles is here for the state. We are taking up the sentencing for the two defendants. A jury found them guilty of several of the counts of the indictment. The jury was hung and did not reach a unanimous verdict as to counts 1 and 10, but they did find Mr. Pittman and Mr. Sanders guilty of all other counts except count 9, which was removed from their consideration. And we need to work through sentencing now. And I am going to start with you, Mr. Hiles, to present what you want to present on behalf of the state.
Okay. And Your Honor, I will be speaking for the family of Mr. Denney. Just a brief statement as to him. They're elderly and are not able to be present.
Okay. Are they Zooming in, or they're just going to find out what happened from your victim advocate?
Well, they have the Zoom, or they have the YouTube. They do not want to speak. She says she doesn't even, Mrs. Denney, his surviving sister-in-law, is not even sure if she wants to be able to look at the defendants, is what she told me.
Okay. But the family consists of Mr. Denney's parents or his sister-in-law? I thought you said parents, but no, that would be some strange math.
It's just his sister-in-law. He had a brother who passed away shortly after this incident.
Okay.
And it is his closest relative is his sister-in-law, brother's wife.
Okay. Got it. So you go in any order you want, sharing that or covering what you think the outcome of the verdict is on the counts.
Well, I'm going to start briefly before I get into my request to sentence. This was a picture that I'd like to share that was requested of the family. This is Lawrence Denney, affectionately known as Larry to the people who loved him. He served his country in Vietnam as part of the United States Air Force. At the time of his death, he had retired after 40 years working for the IRS. He had opened his own private investigation firm, investigating tax-related matters. He was killed on his way to work, which he religiously showed up to at almost 4 a.m. every day at his office downtown, while he was dropping off used books at the Goodwill next to his house that he quite frequently would donate to. So, Your Honor, I want to address what I believe merges and vacates first. Count 1, obviously, there's no verdict. Count 2 is violation of Street Gang Terrorism and Prevention Act, subsection A. There were a total of counts 2 through 6 were all based on subsection A. If you look to Anthony v. State, which is 303 GA 399, a 2018 decision, the Gang Act counts do not in and of themselves merge with the underlying crimes. However, when you have multiple counts from the same subsection that are predicated on the same events and transactions and occurrences, those will merge with each other. So I have that counts 3 through 6 would merge into count 2. Count 7 is subsection B of 1615-4 would stand alone. Count 8 is subsection C of OCGA 1615-4, which would remain standing. Count 9 is not up for decision as it was a directed verdict. Count 10, the malice murder, there is a no verdict reached. Count 11, felony murder. This is the felony murder predicated upon the aggravated assault. That count 12, count 13 would merge into count 11, felony murder. Count 12 would vacate, and then count 14 hijacking a motor vehicle in the first degree would remain, as well as count 15, possession of a firearm during the commission of a felony would remain.
So you believe there needs to be a sentence set for 2, 7, and 8, effectively 3 gang offenses, 11, 14, and 15.
Correct.
Okay. All right. Before you move on beyond that, Mr. Hoover, do you agree with the merger and vacatur analysis that Mr. Hiles has engaged in?
Yes, Your Honor, I do.
All right, Mr. Brown, you agree with that as well?
I do.
Okay. I do as well. I actually wasn't sure, but since the 3 of you concur and I can read Anthony, I wasn't sure what happened with counts 3 through 6, but you've explained that they'll merge into 2 because there would be just one, in effect, one conviction for engaging in criminal gang activity associated with the substantive offenses of the carjacking, the aggravated assault, et cetera.
Correct.
Okay.
Your Honor, I am going to be asking for the maximum incarcerated sentence to run consecutive with each other as to both of these defendants that are here before us. I am going to start with the criminal history of Antonio Sanders. He has the conviction out of Douglas County, which has already been entered into evidence as part of this record. But he has an extensive history in juvenile court, which is directly applicable to this sentencing hearing.
The Douglas County conviction was for entering auto?
And participation in criminal street gang activity.
Okay, so it is like a count 2, 3, or 4. Was it criminal gang activity, or was it furthering the?
It was based on 1615 4A, participation in or violation of Street Gang Terrorism Prevention Act, to wit, entering auto with the intent to benefit the gang.
Okay. Well, to benefit the gang.
To further the interests of the gang, in furtherance of the gang.
Okay. So not, you said it's 4A is engaging in criminal street gang activity.
Yes.
It doesn't say anything about furtherance. Furtherance was, well, maybe it was just different language.
So there's the statute itself has never contained any language about nexus or being in furtherance of the gang.
Right.
However, it was the interpretation by the courts that created that language of nexus and having to say that it is in furtherance of the gang.
Okay. But more importantly, it's a subsection A. So it was criminal gang activity, specifically an entering auto. It wasn't to acquire property or to improve his status in the gang.
Nope, that was the agreement that was reached by the state. All the other charges associated in that indictment were null pros.
What was the sentence?
Your Honor, I do not. It was.
Mr. Hoover will know.
Yeah.
All right.
I don't have that on there.
Okay.
However, his Antonio Sanders juvenile criminal history dates all the way back to 2016. In 16 DL 04625 in Fulton County on the adjudication date of November 17th, 2016. He was adjudicated guilty for loitering and prowling and criminal attempt to commit entering auto under 16 DL 05698. He was adjudicated delinquent on January 26, 2017 to 1 count of burglary, as well as 1 count of criminal damage to property in the 2nd degree. On October 9th of 2018, Sanders was adjudicated delinquent under case number 18 DL 03709 to burglary and obstruction of police. On January 28th of 2019, under case number 19 DL 00336, Antonio Sanders was adjudicated delinquent for 1 count of aggravated assault, 1 count of criminal damage to property in the 1st degree, 1 count of possession of a weapon during the commission of a crime, and 1 count of possession of a pistol or revolver by a minor. On January 28th of 2019, under 19 DL 00337, he was adjudicated delinquent for burglary in the 1st degree. On August 2nd of 2019, Antonio Sanders, under case number 19 DL 02775, he was adjudicated delinquent for entering auto and theft by receiving. And then on August 16th of 2019, under 19 DL 02876, he was adjudicated delinquent for obstruction of police officers. Now, this is all I have for Mr. Sanders. I only had access to his Fulton County files, though there is my understanding other stuff out of Clayton County that
Juvenile.
all juvenile, that I do not have access to. As to Mr. Pittman, in his juvenile history, what I have is a adjudication of delinquency for theft by receiving on February 28th, 2020, as well as an adjudication of delinquency of obstruction of police officers, same date, under case number 20 DL 00811. Your Honor, throughout this trial, we heard repeated evidence of gang activities, of aggravated assaults, responses to. We had evidence of both parties come in of the crimes that they were committing that were discovered in their phones. I stopped well short of going through everything. Throughout the phone dumps, there are conversations of spinning the block on the ops, direct discussions of shooting at or towards oppositional gang members, both at their apartment complexes, as well as seeing them driving in public. Numerous descriptions of chases that were involving Georgia State Patrol, numerous descriptions of entering autos in just in a complete ring, an auto theft ring of cars that were recovered from Fayette County, Douglas County, Clayton County, and South Fulton. Many of those cars were recovered with ridden with bullet holes. It is a continued pattern. Additionally, I did not realize how quickly word would travel, and we've already been reached out. The office has already been reached out to by members of the Camelot condominium community who've instructed to us and told us, thank you for this, because they have had condominiums in that complex, some for almost 30 years now, that at one time were incredibly nice apartments. They still maintain their own apartments to be nice, but these are now elderly citizens that have owned homes for years, and they have watched their property values plummet. They have to get in their homes by night because they're afraid of gunshots or attacks on there. They have seen dead bodies, and they are tired of living in fear, yet they can't afford to sell or move. And so this is a gang indictment. This was an indictment against the gang. This was an indictment against Pittman. This was an indictment against Sanders. And this continued pattern of behavior exhibited by both has kept the local community in fear. And the only appropriate punishment is the maximum sentence. So on count 11, felony murder, the state is asking as to both defendants for life without the possibility of parole. On count 2, violation of Street Gang Terrorism and Prevention Act, subsection A, the state is asking for 20 years to serve consecutive to count 11. As to count 7, violation of the Street Gang Terrorism and Prevention Act, subsection B, the state is asking for 20 years to serve consecutive to count 3. As to count 8, violation of Street Gang Terrorism and Prevention Act, subsection C, the state is asking for 20 years to serve consecutive to count 7. As to count 13, The state is asking, I'm sorry, count 13 merges with count 11.
Right.
As to count 14, the state is asking for 20 years to serve consecutive to count 8. As to count 15, possession of a firearm during the commission of a felony, the state is asking for 5 years to serve consecutive to count 4. Your Honor, this case is an absolute tragedy across the board, but it is an absolute disgrace that Lawrence Denney would serve his country across overseas only to come home and be killed by a group that he fought for their right to associate with each other. And it wasn't their association that was illegal. That is what Mr. Denney fought for. But it was them associating, in fact, to commit these crimes that led to his death that made that association legal. And it's a cruel, cruel irony of the way he met his demise. And by sentencing to the max custodial sentence consecutive, you are sending a message to members of the gangs that this will not be tolerated in Fulton County, as well as the fact you're sending a message to the law-abiding citizens at the Camelot Apartments that our government is still looking out for them and that we still care. That is all I have, Your Honor.
All right. Thank you, Mr. Hiles. All right. Mr. Hoover and Mr. Brown, we can go in whatever order you want. I don't know if you've conferred. Mr. Brown's going to go first. All right. You're welcome to come to the podium. Mr. Pittman won't, should he choose to say anything, but why don't you? I guess it'll be easier. I need you to, so Ms. Rivers can hear you. I forgot she's not in the courtroom right now. So please do come to the podium.
Your Honor, I don't believe that maxing Mr. Pittman out is the only recourse in this matter. He's looking at a lot of years, at least 30 before he would be even considered parolable.
There's no light sentence in this case.
There's no light
question.
sentence. So I'm asking for life with the possibility of parole, and for the other counts, the other charges to run concurrent, not consecutive. By the state's computation, my client will be looking at life without parole plus 85 years. I just think that's too much. It's too much. My client is 20 years old. He should be given a second chance at life. He has no adult charges, and as far as adult criminal history, that is, other than this. And as far as juvenile, it's my understanding all he has is a death by receiving and obstruction. And I was told that he got community service. He was told to do community service for that. So I would like the court to hear from my client's mother, grandmother, and father when the court is so inclined.
Okay. That'll be in just a moment. I have a couple questions, but I want to make sure you've shared everything you want to share.
I have.
Okay. I want to make sure, if it's appropriate, that we get closure on as much of Mr. Pittman's Fulton County business as we can. I thought he had one other case. It's the case that the state was going to share with the jury. They elected not to, about the jail stabbing.
Yes.
Has Mr. Pittman pled to that already, or that's open?
That's still an open case, Your Honor.
Okay. So there is zero adult criminal history in terms of convictions, but Mr. Pittman does have one other open case.
That's correct.
And I'm going to want to talk before we wrap up today about what the plans are for that. The state may have an announcement. They may not. You may have an announcement. You may not. But I don't want to leave that hanging if it is resolvable. It wouldn't move the needle on whatever sentence your client's going to get. So it's my hope that there is an easy way to resolve that, but I'm not requiring that of anyone. It just seems incomplete to say, all right, we're going to resolve things today. Maybe you don't go down to the Department of Corrections because these charges are still there, the jail stabbing. Maybe you do, and we need to bring you back. It becomes increasingly inefficient and difficult for Mr. Pittman to get closure on that piece. But I'll start with Mr. Hiles when we're done with everything else.
Yes, I hadn't received an offer on that charge. We were inclined to enter a plea And my client not having any adult convictions. And if this case had turned out another way, we
Right. It made sense to put that one on the back burner. And if this had gone the way for which you advocated, then a time served on the other one would have made.
First offender.
Right.
Yeah.
Right. That's not how this played out. Okay.
Correct.
I would very much like to hear from each of those individuals. If you'd have them come up one at a time, they'll need to be at the microphone so that Ms. Rivers can take it down.
This is my client's mother.
Okay.
Good morning, Your Honor.
Hi there. Can you tell me your name?
My name is Joy Pittman.
First name is Toy.
Joy, yes.
Okay, Ms. Pittman. I know this is a very, very difficult and sad time for you. If you're able to share a few things, you should. If you can't, Mr. Brown can always speak on your behalf.
I just want to plead upon you, Your Honor, and the courts to have mercy on my son today in his sentencing, because as well as Mr. Denney was a victim, LeAndre was a victim as well. He was a victim by my own occurrence. Because see, LeAndre is LeAndre. He has a younger brother, Cameron, and he didn't grow up here in Georgia. He's born here. But when LeAndre and his brother were 5 and 6 years old, his father's from North Carolina. When they were 5 and 6 years old, his father and myself made a decision to move our boys out of the city to the country, get them a different life. And my son was an on-the-road student. My baby was good. And then life happened. My mama got sick. And I was 8.5 hours away from my mama. And they were saying that her diabetes was so bad that she can lose her sight. And I just felt like I was too far from my mama. And I brought my babies back to Georgia. And coming back to Georgia, we moved to Atlanta, Georgia. LeAndre played basketball and football for Bear Creek Middle and Creekside High School. And my baby was a D1 basketball recruit. And during this time, we were supposed to be picking what colleges we going to. And I'm sitting here before court today with this prosecutor asking you to take my baby away from me for the rest of his life. I haven't touched my child since he was 17 years old. And I was at work a lot of days, so I couldn't sit out there in that gallery. But I sat that phone on my desk every day and I watched this trial. And I watched the pictures that they posted. And I listened. And I heard the prosecutor say how they have extensive clips of his email, of his Instagram account. But he just stopped because they had so many. And I just think to myself, well, if he would have kept strolling, he would have pulled all those pictures up with my son with the basketball team. And they holding the trophies up. And with my son with his AAU basketball team. And you would have saw that too. And if you look at the dates on all the pictures, it was up. That all came within a couple of months. But before all of that happened, the world didn't know my baby. I watched Mr. Warren, the officer that arrested my baby. I watched him testify. I sat in his courtroom. I had to be here when he testified because there was questions that I think that should have been asked of him. Like, how many times have he came encounter with my son? And he could tell you only that one. Only thing that he was able to tell you is that, well, they heard about it or through Instagram accounts. They never had an account of him. They never placed a gun in his hand. I seen them pictures. Them pictures made my stomach turn.
They should.
They could have been props. They could have been real. He never had it in my house.
Clearly, he was doing a lot of things you didn't know about.
I feel like that kids do a lot of stuff, and we can't say that they didn't do it. I can't say that. I know my baby didn't. kill Mr. Danny, come out hard. No, my baby didn't kill Mr. Danny. The evidence, no, that my baby didn't kill Mr. Danny. Was my baby involved with those guys? Yes, my baby was highly involved with those guys. The evidence said that he was involved with them. Do I think my baby deserves a chance to have the life that his father and the rest of us planned for him? I do. Do I think you should be punished when you do something wrong? I do feel how he grew up getting with us, because in our house we punished for what you did wrong, but we punished for what you did wrong. I feel like that he should be punished for what he truly did wrong and not what that he is guilty by association with. And I just ask you, Your Honor, that in sentencing you have mercy on my baby and grant us a life with the possibility of parole to give my baby another chance.
Thank you.
And I just want to second when Ms. Pittman said Mr. Pittman was an honest student. I mean, he was writing notes to me throughout the trial, no misspelled words, good grammar, nothing like what was presented on his Instagram. Nothing like that.
Well, he's bilingual.
If you can call it that.
Yeah.
I guess I don't know. I want to comment more about that Instagram.
Who's next?
Next is Grandma.
Good afternoon.
Good afternoon, Your Honor.
Could you tell me your name, please?
My name is Sansi Pittman,
Can you spell your first name?
Sansi.
All right, Ms. Pittman, what do you want to share with me?
Your Honor, we've looked at each other for the past, this is the 8th day now.
It is.
As I stand here and as I've sat here all these days and listened to your prosecutor make my baby out to be a monster, I don't know that person. I talk with a few of the older women that I go to church with, and what they say to me is, Sansi, you came here chocolate. And when you come here chocolate, you got stripes. And what I said to them, yes, my daddy told me that because my daddy was a veteran. And I learned that I had strikes against me as a veteran as well, because I had things done to me. And I used to tell my grandchildren all the time when my daughter brought them back here, I was angry that she came back. Yes, I was ill, but I didn't want them here in Atlanta because Atlanta was out of control. And I would tell my grandsons every time an officer would come to me, tell your grandsons to stop hanging with those kids that they're hanging with, because those kids have records longer than these tables in these courtrooms. These children have been in the system since they were 11 and 12 years old. Miss Pittman, your grandchildren gonna be the fall guys. Tell them to stay away. And I will continue to tell my babies those same things, but they didn't hear me. Growing up, I was always told birds of a feather flock together, but that is not true. I know for a fact it's not true. I'm gonna tell a little story and then I'm gonna come out from up here because I had asked God to come before me and I feel something bubbling up inside of me. As a young girl, my grandchildren are smart because I was smart. As a teenager, a young girl in 11th grade in high school in Clayton County, where I was the only African-American child in all of my classes, the only. So I was lonely. But finally, another girl came to the school. That girl was a thief and I didn't know it. We got out of school at 12:30 because we were smart. I walked across the street with her to a shoe store. We went in the shoe store. Beautiful shoes everywhere. She had a book bag. So I said, can you hold my bag? Oh, sure. I left out of the store and I go into the Echo Drugs next door. I bought a Snicker bar and a Coca-Cola. And back then when Dixie had the bars, because I'm 60 years old now, basically, they had the little benches in front of the store. Echo Drugs didn't have chips, so I wanted a bag of Lay's. I go in when Dixie and get the bag of Lay's, I come out and I sit down on the bench and I pushed her book bag underneath the table, underneath the bench I was sitting on. She finally comes out of the shoe store with her other bag. So I said, where my bag? I said, it's right there. She snatches the bag from under the bench. And when she opens the bag up, the bag is full of shoes. She looks at me and says, you want some? I said, girl, my mama just bought me and my little sister them same shoes. I got the burgundy and she got the blue. I didn't say another word to her. We walked to the Burger King. We walked directly to the Burger King. We ate and we walked back to the school and got on the school bus. I haven't spoken to that woman since the day that happened. Did that make me a thief? Because I was with her. Sometimes when we get involved with people, even though we think what they doing is cool and it's great and all of that, it doesn't make us be that person. Now, true, he shouldn't have been with them. And true, you see all that repetitive stuff, as my daughter said, never once, and I know they had a job to do, they never once pulled up one picture that said, oh, this kid used to do this. Wonder what went awry. Oh, this kid's on this team. Oh, this kid has got all these awards. Oh, this kid was doing pretty good. No, we're not going to give them a chance. We're going to slam them like we do the rest of them because that's what they fought to slam. That's how I feel right now. I raised 2 sons. He has an uncle that is a state trooper. He didn't come here because of conflict. He had been told also by another person that they really don't have anything on head. He had just been hanging around with these people. And because they talk back and forth, that's the culture of these kids now. That's what they do. A lot of the things that they do and say is not even true. They just doing it because they want to be part of the group. He hadn't been here long enough to be somebody's big homie. He had only been in Atlanta a short while when this took place. Again, like I said, a lot of those officers had already been saying, they know that this is not that kid. Tell him to stay away from them. That was my mistake, that I did not impress upon him more vividly that these people are not your peers. Your peers are those basketball players that you were with when the Nike Elite was reaching out to recruit my grandson. I don't know what the allure is, because I never had a desire to be with a bunch of people. And maybe it was a cause of my upbringing, because I was a loner. And I was always told, birds of a feather flock together. But that is not always true. Because sometimes you do get that little fledgling that's just hanging on because they don't have anything else. And it puts them in the situation that this boy is in right now. As his mother said, he's never been in anybody's trouble. And the stuff by reception or whatever it is, he was with some other kids. Just to take his complete life away from him, it's redundant because that's what happens all the time. You know what I hear people always say that it's a lot of innocent people in prison. That's cliche to me because in a lot of cases it is. I have a male friend that did 25 years because a woman accused him of sexual assault. When that man walked out, he was 56 years old. He'll never have a kid. And she admitted that she lied. I just ask that you have a little mercy and a little leniency and see that sometimes we all do deserve second chances. That's all I have, Your Honor. You be blessed.
Thank you, Ms. Pittman.
Les is my client's father.
How you doing, yeah?
Well, I'm not doing great. I'm sure you're not either. Can you share with me your name, please?
LeAndre Lott.
Last name?
Lott, L-O-T-T.
Mr. Lott, what do you want to share?
Yeah, the only thing I ask you, you have leniency on my son. You feel me? He got caught up with the wrong crowd, everything. He's smart, intelligent, all that, how we raised him.
Why do you think he ended up? And I'm listening real closely to what your son's mother said, his grandmother said. She's wondering what went awry. He had family. He had a basketball team. He had this and that. So help me understand. Maybe there's no understanding it, but
Understanding is opposites attract. People with good lives get attracted to the fun life. It's rich people I've seen that come do street things just because they want to fit in with street people. But they don't have to do that. And I've seen street people want to do the things that rich people do. it's a fantasy of the life, I guess you could say. I don't know exactly what it is. I'm not no psychiatrist or none of that. But to me, it's just this new to me. I'm gonna have fun with it. That could be it. You get what I'm saying? But he has never been locked up with no guns, no nothing. Guns have never been in my house. He already know we would have fought about that type stuff on like whatever. But he has no criminal record outside of this situation. Good people made bad choices. They deserve a second chance too. Everybody changes. I done did some things in my life, Your Honor, that shit I shouldn't have did. I got a criminal record. Not no bad one, but I have one. Just because I have a criminal record don't mean I'm gonna keep being a criminal. People change. I just ask you to give him a second chance.
All right. Thank you, sir.
Thank you, sir.
Mr. Brown, anything else?
Just want to just add to what Mr. Lott said. People do change, and every single human being deserves a second chance. And I just ask for that second chance for Mr. Pittman.
Mr. Pittman, you have a right to say something as well. You don't have to. Your family has spoken, but if there's anything you want to share, now is the time to do that.
I just want to apologize to the family of the victims in Lawrence, even though I have no knowledge of who is behind his murder. I just want to apologize to the family for taking the loss. I'm going to tell my family I love them.
All right. Thank you, Mr. Pittman. Mr. Hoover.
Yes, Your Honor. I first want to address to start off, you asked about the sentence for the Douglas County case, and I believe he got a 10-2 on that case.
Okay. Is that why Mr. Sanders is in the red jumpsuit? It is in connection with was there a revocation, or it's the two-part that he was still serving?
I'm sorry, 15-2. I believe that is why he's in the jumpsuit. So when he got arrested, when I first started meeting up with him, he was already in the Douglas County jail. That case got resolved. Then he came here for that. So I believe that is why he's in the red instead of the blue.
But it's the two-part. There's not been any revocation or anything that you're aware of.
I'm aware of. No, Your Honor.
Okay. Thank you.
Also, just briefly, the state did talk about Mr. Sanders' juvenile history. I'm not going to belabor the point. I know the court is well aware of why we treat juveniles differently, why we address juveniles differently, and just please take that into consideration. The state talked about, first off, brought up alleged communications that was not brought up into evidence, was not presented to the court, was not presented to the jury. I would say, Your Honor, when you're making your determination of the sentence, none of that should be considered. I say that specifically because there's no context behind it. There's no consideration. The state talked about other conversations with other people that they may have found through social media that had to do with other acts. We have no idea what the other acts the state was talking about, but they spent a lot of time talking to you about it right now. I just want to.
You're talking about the people allegedly from Camelot saying, thank you for doing this?
I'm going to get to that next.
Okay.
Before they even got to the Camelot people, the state said there was more stuff they could have talked about.
Got it.
Exactly.
Okay.
I mean, there's no context behind that.
No.
We have no circumstance. That's not proper for consideration when it comes to sentencing based off of the jury's verdict. So I just want to make sure I had to address it because the state brought it up, but I just wanted to address that. In regards to the Camelot residents, Your Honor, I believe that you should take consideration into that, but listen to exactly what the state said. The state talked about 30 years of crime written, or Camelot for all these crimes. Mr. Sanders was what? He just turned 21.
Right. He was -9 when that happened.
Exactly. The punishment in this case for a kid at the time is not going to deter anybody else that's happening. Since he's been arrested, he's been in custody since 2020. There's still crime out there. So I would like to, yes, it should be taken into consideration, but the punishment should be based off of the circumstances and the evidence of this case based off of what the jury came back with. I wanted to make sure I said that as well. And I thought it was interesting that you said our interpretation of the verdict. You want us to talk about that. The state didn't do that, but I have to talk about my interpretation of what the jury came back with. It's obviously number 9 was out because that didn't go to the jury's consideration. However, when it comes to the murder, the actual pulling the trigger and shooting that caused the death of Mr. Denney, the jury didn't come back guilty on that charge as well. in the state of Georgia, I believe as a defense attorney, unfortunately, a person can be charged with everything else and not actually have pulled the trigger. We know the court's well aware of that as well. So I understand that. But my interpretation of the verdict from the jury was that they could not and did not say that Antonio Sanders pulled the trigger that actually killed Mr. Denney. Now, if we couple that with everything else that the state tried to bring up, I think that's a huge part of the consideration when we talk about punishment. The state essentially is doing a life sentence plus 85 years. Like Mr. Brown said, there are countless studies that shows that life plus whatever, that's not a deterrent for anybody. It's not even a deterrent for the person that's getting it. A life sentence is a life sentence. The death penalty has been shown to not be a deterrent for murder. So the fact that they're throwing it up there, that's literally the state asking the court to punish Mr. Sanders for not firing a weapon, but being involved in the incidences that led to the firing of the weapon. I'd like, when you're making your determination, to focus on what it should be, on Mr. Sanders' role in this particular situation. I mean, it's kind of weird where the state can get up in front of a jury and get up in front of the court and say, well, we know there were other people. I don't know who the shooter is. I can't prove who the other people are, even though we know they can, but we want you to punish him to the max and don't worry about what happens to the other people. I ask with that regard, Your Honor, we will be asking for a life with the possibility of parole. However, charge 15, the possession of firearm during commission of a felony, has to be ran consecutively. So it can't be just life with. We're asking that you, since 3, 4, 5, and 6 merge into count 2, we're asking for 5 years to serve on count 2. The others merge in. We're asking for count 7, count 8, and count 11. I'm sorry, count 7 and count 8 to be 5 years to serve concurrent with count 2. We're asking for count 11, which is the felony murder charge that Mr. Sanders was convicted of, to be life with the possibility of parole concurrent with count 2. And we're asking count 14, the hijacking, to be, I believe the mandatory minimum is 10 years on that. So we're asking 10 years to serve concurrent with count 2 and count 11. And again, because count 15 has to be ran consecutive, that to be ran consecutive to everything else. So we're asking for a life with the possibility of parole plus 5 years.
Okay, thank you. Mr. Hoover, do you have anyone, to include your client, who wants to be heard?
No, Your Honor, his family, Mr. Sanders' family.
Thank you.
Mr. Sanders' family has been here throughout the entire trial. It took time for them to even be able to come in today because, like, nobody wins in this situation. I don't believe there's anything they want to say, but they wanted me to just point out they have been here the entire time. His mother and her boyfriend are here right now. After speaking with Mr. Sanders, I believe he does not want to say anything. He understands the verdict. He understands the process he's about to go through. He understands that he's going to get punished, but he's asking to be punished for his role specifically and not the state just trying to punish him for what everybody else did.
Sure. Okay. Thank you.
Your Honor, may I clarify one statement that I made as?
I feel clear on what was said. I'm good. Thank you.
Okay, thank you.
All right. So Mr. Pittman and Mr. Sanders, this is not the first time I've had young men who are only a few years older than my oldest son in front of me for real serious situations. And whether you say you don't know what happened to Mr. Denney, you weren't there, maybe you were there, whatnot, no one can deny this was a serious situation and that you are connected to it in some degree. Ms. Rivers, can you hear me?
Now I can hear you. I lost sound when you said, and you are connected in some degree, and then it went out. Yeah.
Okay. Don't know why it went off. Sorry about that.
Okay.
My point is this. One, we're not dealing with an isolated incident. I don't mean to suggest I'm linking you to other dead bodies, but there's nothing about what led to Mr. Denney being killed that was a first time or a unique thing for either of you. This running and gunning and the culture into which you had both entered was going to lead to things like this. It's just not a surprise to anyone. I don't mean to suggest that the family didn't know this was going on. I can't speak to Mr. Sanders' family. It does seem like, Mr. Pittman, your family wasn't aware of one part of your life because what I heard from them was basketball and student and the kinds of things that make it a little harder for me to figure out how you ended up where you ended up. I didn't get to hear much about Mr. Sanders, but given the juvenile history, which I don't hold against you in any way, it says to me that pretty early on in your life, because of broken family, broken school, broken whatever, you had plugged in with a group that really didn't have your best interest in mind. And whatever that group was doing exposed you to the risk of getting arrested, of getting shot, of shooting someone. To me, one of the more remarkable facts in the case is that when you did get arrested, you're in the back seat, you've got a gun, Baker's in the back seat, he's got two guns, your mom's driving the car. I don't see how things like that happen, but we are geographically proximate right now, but experientially, lives led, very, very different. And so I'm not trying to project my life onto yours. I'm trying to understand your life and how you got to where you were. But I just want to reemphasize, it's a long chain of choices that got Mr. Sanders and Mr. Pittman in cars that were near each other at the scene of the crime, after the scene of the crime, at the Camelot Apartments. That wasn't just a, hey, I've never met you before, let's go do this one thing. And so I, like Sanzi Pittman, wonder what went awry. It is rare to have family members come speak as eloquently as they did about their son, and it's usually a son, not a daughter, and what happened, and their bewilderment as to how you all ended up where you ended up. I don't want to lose sight of what the consequences of all this was, and it doesn't matter in whose hand the gun was. Mr. Denney is dead, and he's dead because a group in which you were intimately involved took people's cars. When you break into cars and take cars, this is Georgia, you run the risk of being shot at. And clearly you guys had guns. And so that means you run the risk of shooting at someone else. We saw what happened in Gwinnett just hours before this situation. And again, it doesn't matter whether either one of you touched that 9mm that left so many shell casings inside the Kia. It was what was going on. And so it's depressingly unsurprising that someone's dead. It would have been depressingly unsurprising if the dead body in the parking lot of the Goodwill was LeAndre Pittman or Antonio Sanders or Mr. Baker, because Mr. Denney could have had better aim. And it just takes one shot to the head, and the body that's left lying there is one of you. And that's just as tragic. But it's a tragedy caused by whatever results in the two of you being mixed up in the kind of stuff you're mixed up in. And I feel for the parents because I don't think they didn't try, but it didn't work. And the structure that you gravitate towards and that gives you a sense of identity, whatever it is the group you ended up in. And it's not a basketball team or a chess team or whatever else you might have been able to do if circumstances were different. I don't think in particular you, Mr. Sanders, were dealt a good hand for most of the years of your life. And here we are. And that's not your fault. I don't blame you for that, but we can't exonerate either of you for that either. It's just sad all around. And you know this both. Yours isn't the only case. I go to trial in 2 weeks. Fortunately, no one got shot and killed, but it could have had the same outcome. And it's guys who were in a parallel YSL spinoff with the green handkerchiefs. And I'm going to have to watch a bunch of the same videos along with the jury. And these videos have 4, 5, 6-year-olds in the video around guys smoking blunts, holding guns, flashing cash. And I see Antonio Sanders, 6 years old in that picture. And I wonder where we're going to be 12 years from now when that 6-year-old is 18. The answer is we'll be back in court. Mr. Hoover is going to have another client. Mr. Brown may have retired by then, maybe not, but he's going to have another client. And we're going to repeat this. I wish there was a way to break that cycle. It doesn't end here, unfortunately, for you all. I'm going to sentence you, Mr. Pittman, as follows. As to count 11, your sentence is life. Count 2, 7, 8, and 14 are all 20 years to serve. They will run concurrently with each other, but consecutive to count 11, Count 15 has to be 5 years, has to be consecutive to the highest count, meaning in terms of consecutiveness. And so I will run count 15 consecutive to count 2. It will be suspended. So the sentence I meant to impose, and Mr. Brown, you should correct me if I did the math wrong, is life with the possibility of parole, plus 20 to serve, plus 5 suspended. And that is what I meant to say in breaking out all the counts. More importantly, on the record, I'm saying it is life, plus 20 to serve, plus 5 suspended.
That's what I understand.
Okay. All right. You guys can be seated. I have to talk to you about your appellate rights in a minute, but I want to turn to Mr. Sanders. Mr. Sanders, your sentence is similar, not identical, but similar. Count 11 is life. Counts 2, 7, 8, and 14 are 20 years to serve. They will be consecutive to count 11. And count 15 is 5 years to serve. It will be consecutive to count 2. Your sentence is life plus 25 to serve. It's life with the possibility of parole. I believe that Mr. Pittman's family and Mr. Sanders' family understands when they ask for mercy. One, I heard them clearly. It is something that I have to balance against the lack of mercy shown to Mr. Denney and anyone else mixed up in this case as victims of all the in-ring autos. But number 2, the legislature has set certain mandatory minimums. The lowest sentence that Mr. Pittman or Mr. Sanders could get for felony murder is life. And I don't say that to say, see how generous am I? There's nothing generous about a life sentence. That is as long as it can be, other than life without parole or the death penalty. I just don't think life without parole is appropriate here. There is a little bit, and this would be in like 2-point font, there's a little bit of hope in that sentence. You will not die in custody if you make different choices while you're in custody. If you roll the way you've been rolling, you're going to die in custody, but not because you aged out, but because you do something in prison and someone sticks a shank in your neck. You know that far better than I do. You have lived a life and I haven't, but I just see what happens. So you'll need to decide the kinds of choices you make while you're in custody. But this sentence is meant to provide a semblance of hope because you are young enough that you can serve this sentence and get out and reconnect with family. And I don't want you to say, gosh, thanks, Judge, because it's not a light sentence. That's not my point. But I understand where the state was coming from. It would have been a legal sentence. It would have been a sentence that resonates with many people to say life without parole plus 85 years. That's not this case. That's not what this case is about. There's nothing good about this case, but I don't think that is this case. It's my job to look at this case along with all the other murders and felony murders that I've dealt with, the defendants I've dealt with, their backgrounds, the opportunities they've had, the opportunities they've never enjoyed, and array you accordingly. And I think that this sentence reflects all those things. It does not reflect my consideration of what you heard Mr. Hiles to be saying about what else is contained in the social media. And it's not a mischaracterization of what the people who live in Camelot now may be saying, as in it's a relief that something is being done. That's not what's wrapped in here. I think it's important to hear from that constituency. This is about the evidence in this case and what I've come to understand about Mr. Sanders and Mr. Pittman through the limited interactions we've had, the amazing representation you've received, and what I've heard from the various advocates here. Gentlemen, you can be seated. I need to tell you about your appellate rights. Both of you, this applies to both of you. You have the right to what we call post-judgment relief. And it comes initially in 2 forms, and you can have both. One is you can have a motion for new trial. And if you decide to pursue a motion for new trial, I'll ask Mr. Brown and Mr. Hoover to file that initial motion. All it is, it says, Judge, something went wrong in this trial. You messed up, the jury got it wrong, my lawyer missed something. And Mr. Brown and Mr. Hoover have 30 days from today to just file that placeholder, Judge, motion for new trial. You will be appointed a new lawyer. You have a right to an attorney for a motion for new trial. That lawyer will work with you, will look at the transcript, and is going to look for all the mistakes that were made. I'm confident there were mistakes that were made. The question is, were they significant enough that it denied you a fair trial? I may have made the wrong ruling on a hearsay objection. That's not getting you a new trial. But I may have made the wrong ruling on something much more fundamental that entitles you to a new trial. So step one would be motion for new trial. If you choose not to have your lawyers file that, you also have a direct appeal to the Supreme Court of Georgia. You have both if you do the motion for new trial first. If you don't, you still have that appeal. These lawyers will file that notice of appeal. They'll step down and I will appoint, I don't pick them, but new lawyers will be appointed for both of you to look at the record, get in front of the Supreme Court and say, hey, there were mistakes made during the Sanders and Pittman trial. Supreme Court, send it back, fix those mistakes, tell the judge to fix those mistakes and do it over again. Either do the sentencing over if I messed up in sentencing, or do the trial over if there was some defect, a meaningful defect in the trial. So you need to huddle with your lawyers to say, I want to do both, or I just want to do that appeal. Now, you don't have to decide right now. It's not a hard decision to make, but you need to give your lawyers that guidance. I promise you, they will, within 30 days, either file that motion for new trial, the placeholder, or the notice of appeal. Then we'll get you new counsel, and it'll take a while, but we'll go through that process. When all is said and done, and you've exhausted those appeals, if that's what you choose to do, and let's say hypothetically the Supreme Court affirms, they say, you know what? Yes, there were those errors, but they don't affect the outcome. We affirm the conviction. We affirm the sentence. You have another appellate channel. It's called habeas corpus. Don't worry about what those words mean in Latin. What it means is you basically bring a civil lawsuit. You bring it where you are housed. So if you are at Putnam County Prison, you would actually file it there and it would be heard in Superior Court in Putnam County. And it's another attack on the conviction, on the process, et cetera. The big difference is, one, timing. That doesn't kick in until you've exhausted your appeals. You'll have 4 years from the end of all your appeals to file your habeas challenge. And number two, this is the bigger one, you don't have the right to counsel. You're on your own. If you can't afford an attorney, you file your own habeas. And there'll be plenty of people in prison who can help you with it, but you won't have a Hoover or a Brown working at your side unless that's something your family can afford. But for the main appeal, motion for new trial and appeal to the Supreme Court, you will have the assistance of counsel throughout that. Mr. Pittman, do you have any questions about your appellate rights?
I have a question. It needs to have something to do with sense.
Okay.
Any way that you put in some paperwork so they can go ahead and get me shipped off or I can start on time.
Lost the podium again. All right, is back on. Ms. Rivers, what did you miss?
The last thing he said was, and shipped out.
Okay, so Mr. Pittman was asking, could I get out of here soon? And the answer is yes. And then I was explaining to him and Mr. Sanders, they both get credit for the time they served. You have your other case. I need to ask Mr. Hiles about that in a minute. But I can ask the sheriff to have you go to the Department of Corrections right away, and then we can sort out what's going on with that other case. Mr. Sanders, do you have any questions about anything I said?
No, sir.
Okay. Let me turn to Mr. Hiles. Mr. Sanders, I believe, has one other case. Or does he have more than one other case here in Fulton County?
He's got at least two.
One is an entering auto, and then one is more complicated than that.
So I intend to request to place those on the dead docket until the appeals process is exhausted.
The entering auto?
I mean, that's fine. Yeah, I'll no process the entering auto.
Okay.
I see where you're coming from on that.
The other one you'd like to, what we'll do is put on judicial hold. We don't really have a dead docket, but we'll put it on judicial hold. Same effect. It won't be an active case. It won't require you or Mr. Hoover or Mr. Sanders to come to court. And we'll let the appellate process run its course.
Correct.
But you're moving to null pros, dismiss the entering auto case.
Yes, only the entering auto as it.
Okay. And what about Mr. Pittman's case?
It's a little more complicated because of the victim, from what I understand with was speaking with trial division. So it's not my decision, but I think it would be okay to put it on judicial hold as it pertains to him for the moment.
Right. I think we're getting tomorrow the third plea. I think there are 4 defendants. I think 2 have already pled.
Okay.
And the third is pleading tomorrow. So it would leave just Mr. Pittman.
Okay. Or if he would you know, if he's willing to enter a guilty plea, I guess
But we're not doing that today. And he clearly wants to get down into the system, so we'll do that. And I understand it's not your case, but I know who to talk to. I just wasn't sure if you had coordinated with Ms. Nix and we're in a position to make an
I have
announcement.
coordinated, well, I have spoken with her about it. And there are a little more complications because about who the victim is.
Okay.
that I don't have information. I'm not privy to that additional information.
Okay, all right. Well, we'll circle back with that. And I think, Mr. Brown, you had agreed to handle that case for Mr. Pittman.
Yes, I filed the substitution.
Excellent. Okay, then we'll keep you in the loop as well.
Yes, sir.
All right. I don't think there's anything else. Anything else from you, Mr. Hiles?
No, Your Honor, not as it pertains to this case, no.
All right. Mr. Hoover, anything else on behalf of Mr. Sanders?
No, Your Honor.
All right. Thank you for your service in the case. Mr. Brown, anything on behalf of Mr. Pittman?
No.
I'll get the final dispositions done today, and we'll get them communicated to the sheriff, so that should get you rolling. If they ask about your other charge, I'll indicate that that's going to be on hold from now, and that shouldn't be a reason for you to stay here. Okay?
I appreciate you.
All right. Thank you, Mr. Brown.
Thank you.